Good morning, everybody. Welcome to our coverage of the People versus Brian Koberger. Bob is not here yet. He's doing a radio tour for the Murder on Songbird Road podcast. So if you haven't heard that yet, you should definitely give it a listen. It's early. I'm tired. Fell back to sleep. I mean, it's really not that early, but I got up early with Scarlett and then fell back to sleep. So to me, I feel tired and early. But we don't exactly know when this is going to go live because they have decided to do part of the hearing in private, in closed session. So let me actually figure out where I need to be to see that it is. Why don't I first start by saying good morning to some of you? Good morning, everybody. See a lot of usual suspects in here. Appreciate you guys coming. And I thought that we might start while we're waiting for court to open up with the hearing from yesterday. I mean, it wasn't nothing substantive, but it was about whether or not this hearing should be closed and about the press and the media trying to, stand up for transparency. And, obviously they've got their motives, but, any push is good because things should be transparent. But at the same time, when you're dealing with motions to suppress, like we are here, and evidence that might never see the light of day, we have seen actual harm from that. We have seen where there is too much in the public sphere that's never getting in at trial, that jurors will hear about it. They might hear about it. They, you know, could hear about it and then deny having heard about it. So as much as I want transparency and I want everything to be publicized, I can appreciate why some of it just shouldn't be. And at least this is a balance, right? I mean, they're going to let the arguments be aired publicly, so we're going to hear, what they're saying. We're just not going to see some of the actual evidence. And I guess we'll have to see if this balance, if we feel after this, going through this hearing, like a balance was actually struck. And I'll ask you guys how you feel about that after we get through it. Let's see. All right, so I've got Court TV up and sort of no, long crime, it looks like. So I don't know if somebody tells me this isn't what I should be doing, I'll switch to somebody else. But for now, that's what I have up. And I'm going to pull up the hearing from yesterday so we can watch a little bit of that. Bob did say he was sending it to me, so it should be in an email. You won't tell Bob how I'm talking about things as I'm doing them. Since that's my gripe at him all the time. "Don't talk about what you're doing, babe, just do it, so it doesn't mess up the podcast," and I guess he's right. It's harder when you're trying to fill air. Obviously, it wouldn't be necessary if I had pulled it up beforehand, so, there's that. I actually lost track of time because Bob's cousin called me, about some health issues in their family, and then I was like, "Oh my gosh, I gotta go." And I lost sort of track of time with that. Alright, look, Jason's got me faded here. Okay, this'll be the camera that we're gonna use. Got it. Alright, sorry guys. Make sure this is yesterday's. Whoop, how'd that happen? This is yesterday. Fix this. Ay, ay, ay. Jesus, guys, this is not boding well for Allison. Alright, hold on. Now I'm getting a call about my daughter's wedding, someone I've been trying to reach for days. Let's figure out why you're not getting any sound. I've not had this problem for some time. Um, I use the link. Let's see. So, Tracy, you sent me the link but it comes back to today's because I think it must reset, like, as the day goes on, and I'm in oh, no, this is East. You did send me the link, and I'm in it, um, trying to figure out why you guys can't hear it. Jeez. Alright, we're gonna edit this shit so Bob misses all this, like, when he rewatches it. No, no. Some screens let you share audio. Let me try it this way. Let's just see if you can hear this.
In an Associated Press, the Ninth Circuit extended the logic in Brooklier.
Anybody hear that? Alright, guys, give me a second. She heard it. Alright, alright. Let me just try to fix myself over here because I don't know what's going on, so give me 1 second. That might just end the stream. I'm not gonna do that. Alright. Gonna rewind it, even though not much was said before this, but alright. Good morning, everybody. This is our continuing coverage of The People versus Ryan Kohberger, and Bob is not with us yet, but he'll be here soon, but what I have booted up and all ready to go while we wait for the court to open session today, um, is what led to this closed hearing and the media going in and asking that that hearing should not be closed. So, let's start there. We can talk about it after. Oh my lord. Oh my lord. What this thing? That's a trick. Alright. How come all of a sudden things up on the bottom just start to play on their own like that? It's like advertising or something.
State is represented, the state is represented by Mr. Thompson, Mr. Nye, and Ms. Jennings. The defense is represented by by Ms. Taylor and Ms. Massoff. The defendant has been excused from appearing. The defendant himself has been excused from appearing today. With us also are petitioners, counsel representing petitioners, Ms. Olson and Mr. Pedersen. Today's hearing was set to address the interested parties' petition to be heard as interested parties related to the court's closure of a portion of the hearing set for Thursday and Friday. So with that, I will let, whether it's, I'm not sure if Ms. Olson or Mr. Peterson is addressing the court today, but whomever is may address the court.
Thank you, Your Honor. It will be Ms. Olson on behalf of the interested parties who are various media organizations and professional journalist organizations with a history of covering the proceedings in this case. And the interested parties thank the court for this opportunity to address this issue regarding press and public access to the hearings that are scheduled to start tomorrow at 9 a.m. Your Honor, as the court knows, the United States Supreme Court has long acknowledged that the First Amendment protects the rights of the public and the press to attend criminal proceedings. And while few cases in Idaho have dealt directly with public access to pretrial proceedings, and in particular suppression hearings, at the federal level, both the United States Supreme Court in Waller versus Georgia and the Ninth Circuit in Associated Press versus U.S. District Court for the Central District of California and in United States versus Brooklier have addressed the issue. Waller did so in the Sixth Amendment context. Brooklier found that the First Amendment right of access extends to suppression hearings, And in Associated Press, the Ninth Circuit extended the logic in Brooklier to pretrial filings, writing in the very first part of its opinion, there is no reason to distinguish between pretrial proceedings and the documents filed in regard to them. Notably, both Associated Press and Brooklier involved high publicity, highly public defendants and charges. Associated Press involved federal narcotics charges against, among others, John DeLorean, and the Brooklier case involved a RICO prosecution against members of the criminal enterprise La Cosa Nostra. Waller, in particular, in its decision, sets out the benefits that the U.S. Supreme Court has seen in its various decisions that arise from public proceedings in criminal cases. It notes that in Gannett, a case in which the United States Supreme Court looked at but did not decide the issue of press access to suppression hearings, that the requirement of a public trial is for the benefit of the accused, that the public may see he is fairly dealt with and not unjustly condemned, and that the presence of interested spectators may keep his triers keenly alive to a sense of their responsibility and the importance of their functions. And in turn quoted other cases. In addition to ensuring that the judge and the prosecutor carry out their duties responsibly, a public trial and public proceedings encourage witnesses to come forward and discourages perjury. Your Honor, prior to closing a criminal proceeding, a court must afford those excluded from the proceeding reasonable opportunity to state their objections. We appreciate the court providing us that opportunity here. And the court must also comply with the requirement set out in Press Enterprise 2 before it can close those proceedings. A criminal proceeding can only be closed if the court makes specific findings on the record as required by that case. And those specific findings need to be sufficient in writing, insufficient so that a party excluded can challenge them. The Ninth Circuit has explained that a court cannot be closed in criminal proceedings unless such closure serves a public interest. There's a substantial probability that in the absence of closure, this compelling interest would be harmed, and that there are no alternatives to closure that would adequately protect the compelling interest. And that's in Oregonian at 920 F. 2nd at 1466, quoting from the Press Enterprise 2 test. Here, Your Honor, the interest parties are not arguing for a blanket order opening the court. We are arguing for the court to adhere to this long-established process of determining how and under what circumstances a court could be closed for a hearing. For many of the media outlets we represent, even in national security, child sex assault, and organized crime cases that they cover, the process that we are seeking has been carefully followed. The public and the media have a right to appeal unwarranted closures of a courtroom, but they're unable to determine whether the court is being closed appropriately because the court so far has not made public the most basic information regarding the reasons for its closure. The defendant in this case, in both its January 13th and January 21st filings, seeks an open hearing and asserts that an open hearing is of utmost importance to him. Therefore, any concerns about the closure being required to ensure the defendant's right to a fair trial are moot. And as Mr. Kohberger pointed out in his motion to hold an open hearing,
Holy shit. What is happening right now? Dude, do I have to start completely over again? I really think I do. Not an Allie, you're muted. I guess I coughed and hit mute. Damn it. Okay, so I stopped it so that I could tell you guys, for people that came in late, what's going on. So part of this, part of we're waiting for the session to open today. Part of the session's being done closed because it's a motion to suppress and the IGG stuff, things that we went over before. And this is a hearing of the media asking the judge to open, to have it all open, that none of it should be closed, and fighting for transparency. So we're going to listen to this while we're waiting for the closed portion of today's hearing to finish up, so that we can hear what they're allowing to be streamed for today. And that is what we're looking at today. As Tracy's pointing out, it still says today is closed. All right.
the Supreme Court in Waller held that when the defendant objects to the closure of a suppression hearing, the hearing must be open unless the party seeking to close the hearing advances an overriding interest that is likely to be prejudiced. The burden is on the party seeking closure. That's from Oregonian 920 F. 2nd at 1467 and Brooklier 685 F. 2nd at 1167. As we understand it, Your Honor, the interest being advanced by the state is concern for information being provided to the potential jury pool and possible inadmissible evidence being discussed in open court. But that is inherent, Your Honor, in any motion to suppress hearing. The whole basis of the hearing is to see whether the evidence should be excluded or admitted at trial. Concern about the public may be learning about this evidence, and even if it ends up being inadmissible, is therefore not an overriding interest. And absent that some evidence that this discussion that would occur in the hearing would taint a jury pool or provide information that would be difficult to seat a jury, I think that is also not sufficient evidence for this court to find that it's a compelling interest and warrant closure of the hearing over both Mr. Kohberger's objection and then the right of public access. It also appears from Mr. Kohberger's filing yesterday that the state asserted that Mr. Kohberger's acquiescence to the non-dissemination order is somehow a basis for them to argue that Mr. Kohberger cannot now object to this closure. Not certain if that was the argument the that the state advanced, because we haven't seen their pleading. It's not on the cases of interest website. But as I understand the non-dissemination order, Your Honor, and its purpose, it's directed at comments or statements that are made outside of court proceedings and pleadings, and not at what can be said by the parties or their counsel in the courtroom. And the very purpose of the non-dissemination order, as I understand it, Your Honor, was to prohibit those sorts of extrajudicial comments by people who would be in the know, but that in-court proceedings are precisely the kind of information that should be available to the public as this case moves forward. Your Honor, I would submit also that there is tremendous public interest, and it serves a tremendous public good for the public to know at the time that it's being considered the evidence, whether the evidence that the state seeks to introduce at trial was gathered in a method that is constitutional or meets evidentiary thresholds for admission. A motion to suppress may be the critical stage of a criminal case. If essential evidence is suppressed, then the government will not be able to meet its burden of proof at trial. Indeed, Mr. Kohberger made that exact argument in his filing yesterday. The purpose of the IGG was to investigate a criminal case. What is more, without IGG, this case would never have been brought against Mr. Kohberger. The public should know precisely what law enforcement and prosecutors did in gathering such evidence and why and how the defendant thinks that was illegal.
Hey, that slow it down request was to me, right? Is that what you guys wanted me to slow this down? I was hoping that we could get to it before it got live, but if it's too fast, I don't mind putting it back to regular speed. Okay, yeah, it was. All right.
The court in Waller, when it was talking about the aims and interests of a public trial, noted that those aims and interests are no less pressing in a hearing to suppress evidence. And then they pointed again to several of the individual opinions in Gannett, the case where many Supreme Court justices opined that if they were addressing the question, they would say there's a First Amendment right of access to suppression hearings, but they didn't reach that question. In Gannett, the comments that many of those justices made was that in many cases, the suppression hearing was the only trial because the defendants thereafter pleaded guilty or the evidence was suppressed and no case went forward. And similar reasoning supported press access to preliminary hearings in one of the few Idaho cases to address access to pretrial hearings, and that was the Cowles case. In Cowles, the Idaho Supreme Court noted that the process in conducting preliminary hearings in Idaho is likewise sufficiently like a trial to generally justify public access. And they pointed to the Supreme Court opinion in Press Enterprise 2, where they state that because of its extensive scope, the preliminary hearing is often the final and most important step in the criminal proceeding. The preliminary hearing in many cases provides the sole occasion for the public observation of the criminal justice system. And that may be the case in a motion to suppress hearing, particularly if either that motion is granted and not sufficient evidence exists to go forward, or even it is denied and a plea deal follows the resolution of the motion to suppress. In a Franks hearing, Your Honor, the court is addressing the very critical issue of whether a law enforcement officer made deliberate or reckless false statements in an affidavit submitted to the court. And prior to holding such a hearing, a court is to determine that whether the defendant has made a sufficient threshold showing that an actual hearing is necessary. An actual Franks hearing, in my experience, Your Honor, is unusual. On issues as critical as these, whether evidence was gathered properly and whether law enforcement made deliberate or reckless false statements to a court in gathering evidence, there is significant public interest, and public access plays a significant positive role in the functioning of the particular process as the court outlined in the earlier cases I've identified. It's particularly true here, I think, Your Honor, with the Franks hearing, where there is that question regarding the truthfulness of the officer involved. In any criminal case, I would submit that it's of extreme public interest to know whether a law enforcement officer swearing that they have told the truth in a filing with a judge that will be used to gather evidence that can significantly impact the life and liberty of an accused, whether that law enforcement officer did in fact tell the truth, or whether the officer made deliberate or reckless false statements. I think it would be different, Your Honor, if it were a private citizen who made a misstatement of facts and there was a hearing about perhaps that person. The calculus might be a little bit different, but this is a person, a law enforcement officer who is cloaked with authority and has the ability to seek process, to get evidence, and ultimately lead to charges against an individual. Your Honor, the last thing that the court has to look at with respect to whether or not to close a hearing is whether there are alternatives to closure. And Your Honor, it is a little difficult in this situation for the interested parties to specify what that alternative to closure might be. But sort of looking at the documents that have been filed in this case and understanding that one of the initial concerns with the IGG evidence is the identity of perhaps family members of Mr. Kohberger, I would submit that there are two alternatives at least that might address that. One is that it's possible, of course, to show exhibits on a monitor in a hearing in court in a way that they're not displayed to people who might be watching online or in the courtroom, similar to what is done when there is a piece of evidence or an exhibit that is offered, but it's not yet admitted. Would also submit, Your Honor, that perhaps redactions or some sort of general identifier, person one or person two, in the place of a particular name would be sufficient if indeed the concern is revealing the names of relatives of Mr. Kohberger. That's very similar to a process that is done in healthcare fraud cases when we're dealing with individual patients whose records may be at issue in a case, and not a medical malpractice case, but a healthcare fraud case where we're looking at the billings, and those individuals are often identified, for example, by a random number or by a Medicaid identifier number, and not by their name. So their names are never revealed in the course of the proceedings. And so, Your Honor, we would submit that alternatives to closure such as that would be available to the court if the concern is identifying those particular names of people who are extended relatives of Mr. Kohberger. Finally, Your Honor, openness and transparency are more important than ever in maintaining and restoring public confidence in our government institutions, in our courts, in law enforcement, in prosecutors' offices, and in institutions of the media. Open hearings, like an open suppression hearing, are necessary to let the public see how this critical part of our criminal justice process works. Thank you, Your Honor.
Thank you. Does either the state or the defense wish to add anything based on Ms. Olson's argument that was not previously presented?
I would like to make a record on behalf of the defense.
Beyond what you did yesterday?
It would be consistent with what I did yesterday.
Okay, but I heard what you did yesterday. So do you have anything new to add?
I don't have new information to add, Judge, other than having the ability to talk with the team about what your suggestion was and our concerns about arguing in open court. Would you like me to just address that?
I'm not sure what you're referring to, so I apologize.
So we had discussed that the evidentiary hearing portion of it for the IGG would be closed,
Correct.
but that we would argue the legal arguments in open court if we did not talk about the evidence that was brought out in the closed hearing. And after thinking about it overnight and talking about it today, we do not think that we can parse the argument that way. So it's still our position that all of this should be held publicly, openly in court. And that's our same position with the Franks. The Franks proffer, with the exception that there will be, in the proffer, there will be a need to talk about specific names and in particular names of some lay witnesses in directing the court to the 1,000 pages that were submitted under seal in relation to the proffer.
All right. Well, with
So
respect to
that's the
the names,
that I have.
I'm sorry. With respect to the concern with respect to using names, submit a list of names with initials tomorrow, and you can use the initials.
Okay, we can do that.
Anything from the state, Mr. Thompson?
Not for me, Your Honor. Mr. Nye was actually speaking on behalf of the state yesterday. I'll defer to him.
Mr. Nye?
No, Your Honor, nothing beyond what was said yesterday. Thank you.
All right. Well, I appreciate the presentation today. I will note this case is a little bit of an unusual posture in that there was previously a non-dissemination order issued in this case in which it was clear the tract of the court and at the time the parties was to avoid given the media scrutiny, the potential for impacting
The jury.
jury pool that exists here, with evidence that may ultimately not exist and evidence that may not ultimately be admissible. That order was challenged, I believe, by the press at the time, and the full hearing was held on that, and the judge issued an order on that. The closure of the proceedings thus far have been consistent with that prior ruling by the court, for which the petitioning parties were given an opportunity to be heard previously. I don't think much has changed in terms of the need to protect the jury pool here, given the intense media scrutiny that has and continues to follow with this case. Part of the rationale presented to the court yesterday for opening it was in order for the defense to make their case to the public. It's exactly why it's not open. We will be challenged under the best of circumstances of obtaining a jury that is not been overly exposed to this, and in particular exposed to evidence that ultimately may not come into this trial. I am, as I told the parties yesterday, particularly sensitive about closing things when we don't need to, and I think that there has been to date a over caution in asking that I seal things by stipulation that perhaps don't need to be sealed. And I've asked the parties to stop that, frankly, and to provide better rationales as to why I should seal what they're asking me to seal. That said, with respect to in particular, the IGG issues, particularly where I don't exactly know what the evidence will be forthcoming, I am concerned about the potential impact on a jury pool. In this case was moved to this court because of the defense's assertion that they could not get a jury pool in northern Idaho that would be unaffected by the case, even with the non-dissemination order in place. The media here in Ada County is as, if not more, intense. And so I think there is need to be careful when we are addressing evidence that potentially is not going to be evidence in the case because of suppression motions, motions in limine, and the like, which is the concern that I have in particular with the Frank's hearing, as that does appear to be evidence that may not come in, and it may not be evidence that has been particularly disseminated to date. As I talked with the party, there are other issues that I've asked the parties not to address specifically as it relates to some of the motions to suppress that doesn't need to be discussed specifically. For example, the evidence produced by the warrants they seek to strike. And is that for that reason, my intent has been and continues to be that we will have as much of this hearing open by way of streaming possible. I have not and will not open the courtroom itself to parties in the courtroom because of the need to close it if I find or the parties suggest to me, and I agree there's a need to discuss something at that moment outside the public's reach, which is easy to do by simply going offline for a minute. And that's what I intend to do tomorrow. In particular, the evidence with respect to the IGG, I think at this point it's appropriate to, and I will issue an order shortly to keep that out of the public domain for the time being. Now, that may change down the line. My order certainly on the issue will ultimately give some information so that people can follow what happened from a legal perspective. But some of the factual details, until I know what those are, and I've seen that, I can't make that determination better. And so I think that this is the best way to proceed because I can't unring a bell once it is rung with respect to potential evidence that in particular may not be evidence in this case. And so my intent would be to proceed with the evidence portion of the Frank's hearing as it relates to IGG in a closed environment. I think we can decide at that time before we go online whether we can have the IGG portion of the Frank's proffer publicly. The intent is, I think we understood from discussion yesterday that the rest of the evidence and the arguments, both on Frank's and suppression as it relates to everything else, we should be able to do public. If there's an issue that is specific, like Ms. Massoth brought up, about the need to mention a name that we need to protect from unwarranted harassment, which has been a concern in this case, we can certainly refer to them by initial, particularly if you give me a roster with initials or other identifiers you'll be using, then I can follow along. And I think that's the better way to proceed so that we can do as much of this in open light as possible. So I appreciate the petition. I don't think it has changed. I appreciate the defense has shifted its position to a degree here. I'm concerned that the purpose of the shift is to try the case publicly as was offered to me. That doesn't give me comfort, to be frank. But for the meantime, until we can, I can get a handle on the exact evidence that does in fact come in, given that it is potentially evidence that will not be admissible, and anyone who hears about it may therefore be removed from the jury panel. I think it's better that we proceed in this fashion for now.
May I raise one other issue, Your Honor?
Briefly.
Thank you, Your Honors.
Can you all hear me? You're muted. If you can hear me, you've been muted the whole time. I'm muted too.
Nothing like that has happened until you got on, babe. I don't even understand. It's like you
No.
came in and all of a sudden I got muted. It was like
All right. So here's the proof. The muted messaging was coming in way before I
all
got
right,
in.
all right, all right. I know. I was trying to blame you. There's
Aw.
a lot you don't know, and you will never know if things work out
Welcome,
the way it should.
welcome to the world of the muted.
I
So what's
must be
good?
muted since I put it on to scream up to you. Jesus.
Wow.
I just
That's
can't even believe
epic.
it.
That's epic. Didn't anybody use the muted? Like,
We
I don't
didn't
see
upload it yet.
what?
No, we still need to upload that soundtrack. I
No,
gotta
no,
do it
no.
right now.
No, but like the muted emoji. You're muted. Like no one used it. I don't see.
Oh god. Muted,
But
muted, muted. All right. So I paused it and I said, wow, this is so I am really upset about this whole muted situation. And but this is definitely the first time it happened, babe. Did not happen earlier when you weren't here to see it.
all right.
Absolutely did not happen earlier. Never.
Okay. I wasn't suggesting that it had.
I know, but clearly I am by saying that, right?
Oh, are you saying that it did happen?
Nope, did not happen. I don't know what you're
Oh,
talking about.
I mean, see, listen, man, like if you mute to cough,
I
like
think
in
that's
and
what it
you're
was.
listening to a hearing, that's when it happens, you know. It's sneaky. It's sneaky, the old mute.
All right. So I muted it and said, first of all, I said DB answered what IGG was. Um, and that if for those of you who don't know, that here the police went um to the parents' house and used DNA that they found in the garbage or what was it, a soda can or something what they found in the garbage to extract the DNA, compare it to Kohberger, and find that it was um, a familial match because all of the male DNA will have the same mitochondrial DNA. Um, the wait, sorry. Um, will have the Y chromosome will be the same for all men for thousands of years in their family line, and for same for females. Um, it's like a sub DNA of their DNA. But in any event, it seems the argument that they're making is that by allowing the IgG evidence in, it's going to invade the privacy of people who are not parties to the case. I think that's the argument. I didn't hear yesterday's argument, but here, yes, sometimes when they're trying to identify somebody, they take that sub DNA of your X or your Y, of your maternal line or your paternal line, and they compare it to the database and people who are criminals, and then it's like they get a cousin, and then they go backwards and they find this person, then they find that person, so it could involve a lot of people. So I'm not sure if it's precisely that argument or just that by introducing the um the IgG or essentially the mitochondrial DNA, it's going to make it appear as though there is a stronger DNA connection than there actually is. And maybe we'll be able to discern some of that through their closing arguments. Um, but
So can I jump in?
yes, because
So
you know more.
well, no, I don't, but you look like you're watching yesterday's hearing. So
We
that's
are.
what
Everybody knows that we're waiting for today's hearing to start.
okay. So I just want like, and I found this like as a law nerd to be a very interesting argument, and it's an important argument. It goes to the transparency and public trials argument, like what, like where are we going to draw that line? Because we're seeing it's becoming more and more prevalent, more and more common with courts to close or seal courtrooms when particular evidence is coming in, and like as defense attorneys. And I wanted to ask you, do we like that? I mean, the concept is that they don't want evidence that theoretically could be inadmissible, meaning that it won't come in at trial, getting out to the public because the public, once again, as always, makes up the jury pool. So, I mean, as defense attorneys, conceptually, I think we like it, but as a trial observer, I hate it. What do you think?
Yeah, no, I said that before you before you got on, is that, obviously they're going in with this transparency argument and taking the high road, but we know the media has ulterior motives, but at least someone's fighting for transparency. But that as a matter of law, when you are talking about, and we have seen it happen where too much evidence gets into the public sphere and it does taint the jury pool, and it does become an issue for something that's either never going to get in or doesn't stand for the proposition that it stands for. So that I understand from the legal perspective why the judge would want to keep out things that are never going to make their way into a trial. And I just want to sort of also cut in here is that, yeah, when I say mitochondrial DNA, technically it's the female line, because there is not like a true mitochondrial for the male, but it I use it interchangeably, and maybe as years have gone on, they refer to the men's just as YSTR or something. So maybe that's a better way to call it. YSTR, saying that they are taking the Y and creating its own DNA, doing it. That's where I was saying like a sub uh, profile. So they break down the Y in the same way that they do like the main DNA. So I should refer to it as the YSTR. Wow, Afton really called me out. Thanks, buddy.
About what?
Lots of us use the muted emoji. So they were
Oh,
using it is what they're saying.
no, he was calling, or she was calling me out because I said that no one used it.
I know, but I said it also calls me out because they were
Well,
all
the
using
problem
it.
is in StreamYard, we don't see the emojis. We just see the description of the emoji.
All right. You know what? Start talking because I'm about to upload that soundbite so that
All right,
you all can
listen,
give it to me.
why aren't we just listening to the hearing?
Well, we are. I just broke because we went through, the judge gave his answer, and then one of the lawyers said, "Can I say something else?" So I decided to take a little pause and engage with the listeners.
Oh, is this the lawyer that he said, are you just going to say the same thing that you said
No, nope.
yesterday?
He said to defense counsel earlier. She said
Right.
something different. This is the attorney who made the argument the whole time. He gave his ruling, and then she's like, "Wait a minute, I want like one more chance to say something to you." So
Okay.
she's gonna go. She's gonna go again. Um. Uh, all right. Let's both mute ourselves while I start this up.
Okay.
So first, Your Honor, with respect to the non-dissemination order, respectfully, we represented the interested parties at that time as well. And our understanding of those proceedings, it was amended a couple of times. The second time after we moved to intervene and challenge the dissemination order then in place. And as I understood Judge's the proceedings in front of him and the non-dissemination order, the purpose of that was to preclude extrajudicial statements and was not to preclude the attorneys from saying things in court that would be made public. The goal was to make sure that there was accurate information from people knowledgeable about the proceedings, and that was the forum in which they could do it. And I would also note that Rule 3.6 does have sort of this rebuttal portion to it that allows if there is a statement that is made, under Rule 3.6, the defense is permitted to make public statements to sort of counter that. And I think that's probably what the defense was getting at in its submission to the court. And then finally, Your Honor, are the court's statements in court today intended to be its specific findings regarding the manner in which the court is to implement the Press Enterprise 2 test, or will there be a written order so that my clients can be adequately prepared to decide what next steps to take?
Yeah, as I indicated, I intend to issue a written order following today's hearing. I don't think that what you said accurately reflects my understanding of the defense's position yesterday, but I appreciate that. I do understand judge's prior order to be dealing with extrajudicial statements because that's who he could control at the time, were witnesses and parties. But I also understand from a review of the record, there has been a concern throughout this case of exposure to evidence that may ultimately be inadmissible, and that prior proceedings were closed for that purpose, consistent with judge's ruling at that time. I agree it would be an extension of that, but in general, I think that's where they've been throughout this case. So, at the end of the day, regardless of the outcome, the likelihood is everything will be unsealed. And before then, as soon as it can be done in a way that protects the case and the jury pool, which is the parties' rights, both parties' rights to a fair trial is paramount, as is the public's right to know. But I also have to weigh that against the ability to have a fair trial by getting a jury panel that has not been tainted by the publication of widespread publication of evidence that may not be admissible at trial. So it's a bit of a narrow path for the court to have to tread, and I appreciate that, and I appreciate that that calculus isn't always in the direction that one would hope, but I am doing my best to make that calculus in a way to ensure the rights of the parties and to ensure a fair trial, and that we can do that as quickly as possible. All right. So I will issue an order forthwith, and tomorrow we will come forward with public hearings just as soon as we can. Further, if after hearing that evidence I determine it doesn't need to be protected, I will order a transcript be prepared, and I will order that be produced. But in the meantime, I think I need to take this course, so I appreciate that.
So what is this course?
So his course was, his course was that he's going to close it for the portion that he thinks it needs to be closed. He's going to open it when he damn well thinks it should start to be opened. If while it's opened, he decides it needs to be closed, he's going to take us off stream. And if he decides after he does a portion of it open that closed, that there was no good reason for it to actually be closed, he's going to produce a transcript and make that public.
Yeah. All right. So, I mean, do you have the court Zoom up?
We do.
Okay.
We do. I mean, you want me to just stick it in showing nothing so that people feel like they know they're not missing anything?
Yeah. Because none of us believe you, babe. We all think
Okay.
you're lying. We think you're trying to withhold motion hearings from us.
But I can, just so that we all
Yeah, Scorpion, this is such a great point. And this has always been my argument. And when you say anyone, that includes law enforcement. You know, like therein lies the rub. Like I've been making this argument for a couple of years now. I think IGG is amazing. I think it is an incredible tool. I think it is a tool that can identify John and Jane Does that have been unidentified for decades and decades. I think it can really help solve crimes. I've made the argument, and I am going to die on this hill, that because of the nature of DNA, because of the fact that we share DNA with our ancestors, that there is an expectation of privacy element to it. And which means that, like, typically, and we always give the example, like, say, for instance, you have a buddy who, dabbles in the criminal element a little bit. And, one night you're sitting at home watching, rewatching Friday Night Lights, like I'm doing right now. Allison's like, this is a kid's show. I'm like, what? No, it's not. The show's great. And the pounding on the door. And I'm like, oh my God, like, who is coming to our house unannounced at this time? So you go open the door, and so it's a buddy of mine. He's like, dude. He runs in. He's like, hey man, I got to leave this gun here. Throws the gun under my couch. I'm like, what, dude? No, you're not leaving. He's like, dude, I gotta go. Takes off. say a day later, the police come, they search my house for whatever reason because they saw him come in, and his lawyer tries to file a motion to suppress because the cops just came in, they didn't have a warrant, they found the weapon under the couch, and now my friend's lawyer is going in saying, well, that was a illegal search and seizure. And the judge is going to have to say, well, sir,
Too bad,
I'm
too sad.
sorry. That's a real shame. And you're probably right as to the Matas. However, as to your client, that person has no expectation of privacy in the Mata's home. Therefore, I cannot rule in your favor, nor can I even hear it because you have no standing to bring the claim. So it's kind of the same concept when you're talking about IGG. I think that there is an expectation of privacy because what exists in the world that gives more intimate information about us than our own DNA? So all I'm suggesting is not that law enforcement not be able to use it, but get a goddamn warrant. Get a warrant. It can't be used as a tool for fishing expeditions. Go get a warrant, develop other evidence, develop some probable cause in order to get the warrant to use the IGG. And then I think that solves all the issues. This is going to be, and I've said when this IGG became a thing in this case, it was my prediction, if there is a conviction in this case, that this is going to be the case that goes up to the US Supreme Court because it's going to have to be dealt with. It's going to have to be dealt with the high courts because I'm not the only attorney making that argument out there. There's plenty of legal scholarly articles out there talking about this exact same thing. And it's really a fascinating question. It's because it's like we're like on the verge of Minority Report type, pre-crime stuff where we're going to be able to use technology to really be able to solve crimes, but there has to be parameters because our rights have to be paramount. We have to always be concerned about our rights. And as much as we want to get the bad guys, and we do, we definitely want to get the bad guys, we have to protect our rights above all else, because if we start allowing the government to do whatever the hell they want to do, we're going to be living in a country that we do not want to be living in. And it'll happen very quickly. It'll happen very low key decision. Like that's how they always chip away at our civil liberties and our rights, is case by case, a little piece by little piece. It goes under the radar unless you're a defense attorney or somebody that works in the criminal justice system that reads case law and understands, oh, well, yeah, now they've allowed searches of your vehicle based on this. Oh, well, that has really chipped away at our rights to be secure in our persons and in our property. And, it's like those things until they're out there in the public sphere in terms of appellate issues or in hearings that we're now watching. That's why I love that we're now watching pretrial motions so much. You guys know how much I'm always talking about that. That's where the real war is always fought in any case, are these pretrial motions. But more importantly, it makes us, the citizens, especially y'all that aren't lawyers, that don't read case law, that don't understand what the current state of the law is, it makes you aware of the fact that now this is what the law is. This is what the government's able to do in terms of, did they have probable cause? Was that a valid search or not? So it's a really interesting concept. So I hope we get to hear a lot of these arguments today, because I think they're going to be really interesting. Because as far as I know, there's a motion to suppress and a Franks hearing. Those are both taking place today.
It sounds like the court is only talking about closing the IGG portion, or part of the IGG portion, but he also did say there was part of the Franks that may never, make it in. So maybe he did say
I believe they're intertwined. They're both intertwined with the IGG. I think the motion to suppress as well as the Franks, because,
I'll be right back.
To me, a really interesting aspect of the search that took place. And again, if you guys aren't familiar, and I don't know if Ali already talked about it, I don't know if the search was legal, because obviously they pulled the garbage from the Kohberger's home. Now, the question becomes, they live in a gated community. So is there an expectation of privacy within your gated community that requires them to get a warrant to get into the gated community? It's a really interesting legal argument, and it's one that is going to be had. And I'm sure that's going to be one of the primary thrusts of the argument today. So yeah, I hope we get to hear all the argument, because it'll be really interesting. The other case that we're keeping an eye on, which from what I've heard, is Corey Richins is up today. And I think what I heard about that is they're not going to be streaming it, but the audio is either going to be released, or they're going to have the audio running while the hearing's taking place. So I'm going to keep my eye on that. Kind of the thought process going into today, knowing that there was going to be some limitations on what they were going to show with Kohberger, was maybe to bounce back and forth between Richins, if in fact they are going to play the sound simultaneous to when it's happening. Then maybe I thought we could bounce back and forth to see what was going on over in Richins. And then tomorrow I had asked Tracy and Mandy to figure out, I know Steins is up, which is, if you guys aren't familiar, you should be. It's a really interesting case. It's the sheriff who shot the judge in Chambers case down in Kentucky. I know that's up tomorrow. I'm not sure exactly what it's up for, though. I think that there's probably a motion or two that's been filed in that case. So we'll keep an eye on that. So I'm gonna see if I can pull up the Richins. Like, I don't know. Like, I forget, like Tracy just asked me in the text. Somebody said that Steins is up tomorrow. So I don't know. Are you not seeing that, Trace? I can't remember who told me Steins was up, but somebody did. I'm not making it up, unless I dreamed it, which is possible. Could have dreamed it. Let's see. I saw DB had an interesting comment that flew by. So DB says, gated community, private road, not by the curb, private trash contractor. They knew it was illegal. That's why they didn't get his DNA out of the trash. They got his dad's. Right. But I mean, it's like, it's the same concept when it stretches to the IGG. You know, that's the whole thing.
Wait a minute, but also he was, but wasn't he living there at the time? Had he not come back home? I mean,
Well,
that's his domicile. He's just away at college. I don't, he might have some continuing fourth.
well, DB suggesting that either way, that they specifically didn't pull his DNA out. I mean, I guess the pushback,
how would they know?
right? That's the pushback. Like, how do they know what they're pulling out of the trash? Has
And
dad
they did,
his?
right? They did pull his DNA out of the trash because his dad and him have such similar DNA as they are able to accomplish this task from that. I mean, that's part of the legal argument as well. I don't know that argument works, because I do remember us discussing it's a gated community, a private road. So that may make it, that may have the
Green says
expectation.
there's no expectation in gated communities according to PA law, which is interesting. So we are both licensed in Pennsylvania. You should pull that up and see if you can find out what the law is, and which would be surprising to me.
Yeah, that would be surprising to me too. So I'll double check it. But the judge may have ruled that already, because it was a pending motion. I remember that being.
It was. Well, I don't know if they've ruled. Like, we're just now starting to get into the substantive motions in this case. Like, we had the motions to dismiss based on the constitutionality, which I like. From a law nerd perspective, I kind of loved Ann Taylor's argument on that. Like, that was the one where I was like, I bet you she's been sitting on that argument for 20 years. You know, every time she's out to dinner, I'm just waiting for the case to come up where they use the grand jury and, you know, the standard is incorrect because there's a conflict between the the Idaho Constitution and the rules that the Supreme Court has laid out in terms of what burden they have at a grand jury. Remember that? Like she
Yeah.
made that argument and people were like, that's the stupidest argument. I'm like, on its face, I guess you could argue that it's kind of a goofy argument because obviously we know that a grand jury is not going to be beyond a reasonable doubt, which is the argument that she was saying because the Idaho Constitution did state that. Like it did state it. And there was never kind of a correction to the Constitution itself. Like they didn't amend it to match with what the Supreme Court rule was.
Right. It was an interpretation of it.
Right.
So, we paused it right as that lawyer said she had more to say, and then I think we didn't go back to it. Should I put that back up?
Yeah. I mean, what else? Like, let's hear the whole thing.
Yeah, I
Like,
know, but then you asked me if the other one, and then I got distracted. And
oh
put the other
no,
one
yeah.
up.
No, yeah. Like let's just hear it out. It's an interesting it's an important argument. And interestingly enough, I don't know if you're seeing in the chat, which I knew, it's not the defense who's trying to keep this thing shuttered away from the public. It's the prosecution, which, it always rings hollow.
No, the judge did mention specifically that he said that the defense had shifted its position, but he's worried that its shift is for the precise reason of wanting to try their case in the public sphere. So
well,
it sounds
that it shifted their position from which to what?
well, based on his comments, to not arguing that it needs to be closed.
Well, that's what I'm saying. But who really was picking the fight was the state, which again, it really rings hollow anytime the state is claiming that they're so concerned about the defendant's right to a fair trial. It's like, yeah, they take the oath the same as every attorney does to uphold the Constitution, but they're full of shit. Like they want convictions. So anytime it's a prosecution, like they did in Garcia, the same thing. Oh, we're challenging Garcia's competency because we really want him to have a fair trial. I'm like, yeah, sure you do.
I just want more time because there was a discovery issue. I think this is what was going on at that point.
Yeah.
All right. I'll play this. Here we go.
May I raise one other issue, Your Honor?
Briefly.
Thank you, Your Honor. So first, Your Honor, with respect to the non-dissemination order, respectfully, we represented the interested parties at that time as well. And our understanding of those proceedings, it was amended a couple of times. The second time after we moved to intervene and challenge the dissemination order then in place. And as I understood Judge's the proceedings in front of him and the non-dissemination order, the purpose of that was to preclude extrajudicial statements and was not to preclude the attorneys from saying things in court that would be made public. The goal was to make sure that there was accurate information from people knowledgeable about the proceedings, and that was the forum in which they could do it. And I would also note that Rule 3.6 does have sort of this rebuttal portion to it that allows if the defense, if there is a statement that is made, under Rule 3.6, the defense is permitted to make public statements to sort of counter that. And I think that's probably what the defense was getting at in its submission to the court. And then finally, Your Honor, are the court's statements in court today intended to be its specific findings regarding the manner in which the court is to implement the Press Enterprise 2 test, or will there be a written order so that my clients can be adequately prepared to decide what next steps to take?
Yeah, as I indicated, I intend to issue a written order following today's hearing. I don't think that what you said accurately reflects my understanding
Oh, maybe
of
we did
the
play this.
defense's position yesterday. But I
I did play
appreciate
this
that.
already.
I do understand Judge's prior order to be dealing with extrajudicial statements because that's who he could control at the time, were witnesses and parties. But I also understand from a review of the record, there has been a concern throughout this case of exposure to evidence that may ultimately be inadmissible
I did play this
and
already.
that
Sorry.
prior proceedings were closed for that purpose.
No, CH
Consistent
is
with
saying, pause it, babe.
judge's ruling at that time. I agree.
Yeah, that I played this already.
CH is, no, she's saying you didn't. He's doubling down.
Oh, okay.
So, but let me throw up this comment. Once trash goes into the trash dump truck, police can grab it legally. Absolutely. Not only that, if your trash is out on the curb with the curtilage, then at that point it's fair game. Any point that the public has access to something, you no longer have an expectation of privacy in that particular that piece of property. Like, so if you bring your trash out to the curb where I can pull up to your curb and pick through your garbage, so if I so desired, same concept. Cops can do the exact same thing, and you're not going to have any kind of basis for suppression based on a violation of your Fourth Amendment right. So yeah, keep that in mind, kids. You put your trash out at the curb, it's open season on that. Like, and don't dox me. You should go and listen to the Gacy tapes, my first season of Defense Diaries, because that's a major thing that I uncovered in that case in terms of how they got the primary piece of evidence in that case, which, had it been discovered by my father and Sam Amaranti prior to trial, would have had devastating effects on the conviction or the ability to be able to convict that horrible, horrible piece of shit, John Wayne Gacy. I highly recommend you listen to that, because I go into that in great, great detail in terms of the law with respect to that. Plus, it's just a really good podcast. Go ahead, babe. Fire it up.
Okay.
It would be an extension of that, but in general, I think that's where they've been throughout this case. So, at the end of the day, regardless of the outcome, the likelihood is everything will be unsealed. And before then, as soon as it can be done in a way that protects the case and the jury pool, which is the parties' rights, both parties' rights to a fair trial is paramount, as is the public's right to know. But I also have to weigh that against the ability to have a fair trial by getting a jury panel that has not been tainted by the publication of widespread publication of evidence that may not be admissible at trial. So it's a bit of a narrow path for the court to have to tread, and I appreciate that, and I appreciate that that calculus isn't always in the direction that one would hope, but I am doing my best to make that calculus in a way to ensure the rights of the parties and to ensure a fair trial, and that we can do that as quickly as possible. All right. So I will issue an order forthwith, and tomorrow we will come forward with public hearings just as soon as we can. Further, if after hearing that evidence, I determine it doesn't.
Right. So I had definitely played that before. Whatever. We heard it again.
Yeah.
So
Tracy, did you send me the link for the Richens audio? I can't remember where somebody sent it to me.
So I just want to note, and Tracy or whoever's ever back here with us, if you go into the sounds, we now have
Bob, you're muted. Bob, you're muted.
What about Allie? You're muted.
No, we don't need that. That's never happened.
Wow.
It's never happened in the history of YouTubing.
I feel like I'm being gaslit right now. Gaslighting.
See, only Bob will use gaslighting. I think we all need to yell at him. You can't use it when the person's clearly, saying something in jest, when all the people here know that I was muted earlier.
How can I possibly know if you're saying something in jest?
Well, we had already had a discussion about how I was
stereophonic.
muted.
You're
Did
a
we or
very
did we not?
I don't know.
I hate Bob's misuse of gaslighting. It really irritates me.
This is a true story. It does very, very, very much irritate the shit out of her. All right, hold on. Yeah, Tracy said she sent. Let me see what the deal is here. see Tracy. Okay, let me. It'll be an audio link, which I've included. Okay, so let me see here.
You can put this down as soon as you're ready. I'm just putting it back up.
Okay, hold on. I'm trying to see if we've got. It's a WebEx. So let's see. Don't have WebEx. I wonder. I can't tell if it opens somewhere. Let me see if there's another screen. Okay. Yeah, I don't. I think that wasn't supposed to start until maybe 11:30 our time.
Oh Lord. We should just completely scratch this. You know what? When it starts over, we should reintroduce it and start from there. 'Cause
Wait,
there was a
reintroduce
lot
what?
of mishigas happening before you got on.
What do you mean?
Like we're starting over, so Darren can use that as the podcast. Like whenever this goes live, or you just need to do the recording separately so that he can just start it when we start. Oh, 10:30 Mountain Time for Richens. I thought you were
Yeah,
talking about Kohberger. I was still reading about I can find nothing about gated communities and garbage being it's, like, bizarre to me. I don't understand what's going on.
it's kind of novel. It's a novel
I
issue.
mean, it can't be that novel.
Can't be that novel. They've had
No.
gated communities for a long time.
Right.
Seems like some lawyer would have brought that up at some point. Okay. Oh,
I mean, I'm definitely finding stuff about gated communities as it relates to your right to privacy in general, just nothing about garbage or trash or curtilage.
okay. So, well, this is exciting. The the Academy Award nominees for Best Picture came out. Wow. I have seen. Oh my God. Allie, The Substance is nominated for Best Picture.
I can't even believe it.
I can't even I know
Oh,
that she won the Golden Globe. Like Allie and I watched that. And I was stunned. So these are the nominees. Honora, haven't seen it. The Brutalist, haven't seen it. A Complete Unknown, haven't seen it. Conclave, haven't seen it. Dune Part 2, have not seen it. Amelia Perez, have not seen it. I'm Still Here. Now that one, I feel like I'm no, haven't seen that either. That's the Brazilian flick. Nickel Boys, nope. The Substance, it's the only one I've seen, and didn't love it. It was so weird, and I like weird movies. I do. And Wicked, which we have not seen. So it's a lengthy list. I don't know. Have you guys seen any of those? Dune 2, incredible, huh? I have yet to. I'm not gonna lie. I haven't even seen Dune 1. I need to invest 3 hours and watch it because oh, DB firing on old Bill Thompson. But that beard though, I mean, he's like a lumberjack that just ambled into court one day. Hello, I'd like to try a case. Do you guys want to hear a case? Sit on down. I want to tell you a little story. Let's see. So what do you want to do, babe? Do you want to cut the live and then we come back when something happens?
I mean, I'm thinking about it.
I like I can't put my finger on it, Leah. Like I don't know, or Lee. What do you go, Leah or Leah? Or Lee or Leah? I would say Leah, right? But I've seen people that, oh, Tay, are you new to the party? I do so many impersonations. Usually when we have some dead air, like when I've got time to kill, that's when I'll bust out some impressions. So what did you think of Substance, Allie?
I did not like it. It
I mean, it
went
all,
off the rails as far as I'm concerned.
I mean,
Stand
conceptually,
by.
it was an interesting idea, right?
Yeah. Stand by.
Uh-oh. Oh, wow. She's having an important phone call. Look at that. There's Allie in action. Look, guys, Allie's in action. She's lawyering. Oh, wow. Shit got serious. That was in case there were any like lip readers out there. Would have destroyed privilege, maybe, if she's on a yeah. All right. So I think Tracy has confirmed that Steins is not up. So prank call, prank caller, prank call. That's not really happening tomorrow. So I'm trying to figure out what we're gonna do tomorrow. There's not really. I know that there's some channels. I know G and the Grizzlies are streaming that one trial, and I know Lee is streaming that same trial. I think, which seems kind of interesting to me. Like they're all interesting once you dig in, but I'm too late. I'm late on the game on that one. So I'm going to take a peek and see what I can see, try to figure it out. But so here's what I think we we might do is keep an eye. We'll keep an eye on Kohlberger. I'll also keep an eye on Richens, or an ear, as it were, on Richens. And if one or the other, because I have a feeling that we might be drifting into the afternoon before we see anything on Kohlberger. Because if he's hearing both, if he's going to decides to do it where he's going to hear evidence on both motions, which is unorthodox, where he's going to say, okay, I want you to present the witnesses and evidence on both of the motions. And then what we're going to do is I'll hear all that. And then after that's done, then we're going to fire up the stream, and then you can give your arguments as to both motions one after the other. So I don't know if that's how he's going to do it.
I think you make a good point. Let it stand by, and we'll come live as soon as something's happening. And I guess you're saying in either of the two cases. And then just to answer Lee about the substance, towards the end, I just thought went a little off the rails. Like it got like it was mostly like the very end, like the stuff. I don't want to ruin it for anyone who hasn't seen it, but like yeah, like the last, I don't know how many minutes, but I'm sure if you've seen it, the part that I'm referring to.
Who was despite the look, give me more. Like I'm not even aware of that. It sounds like an important case. It sounds interesting. And was that a jury trial? So that would be civil. It's probably why it wasn't on my radar. Defamation's always going to sound in civil law. So
We'll look into it. Let's say goodbye because I got to talk to you about that call.
Okay. All right, you guys, we love you. I will create, here's what I'm going to do. But like, all right. So Allie, try to kill like 2 minutes while I create a new live, and I'm going to portal everybody to the new live.
All right. All right. So let's see maybe if defamation, I mean, despite the look on my face, you're still talking, which is an awesome name. Yes, in Florida, CNN lost. Cool Lady says Lori Daybell's having a hearing today.
What?
Mama 2 SL says Ashley Benefield had oh wait, we did know about that.
Oh, yeah, I forgot we did. Like, I know she was asking for bail pending appeal. Was that televised?
And that's typically a better argument to make once you actually win your appeal. Even, because it's not like you're automatically getting well, depending, I guess, on the type of appeal that you have, but I'd be interested to know. I'd be surprised if they gave her bail. But CNN lost, huh? I mean, Lori, the reason we use Valo for Lori is because that's the name she was tried under. Or was she tried under Lori Vallow Daybell?
It was Lori Vallow Daybell, but one of the things that she's asked is to drop the Vallow in the case where she's being charged with conspiracy to commit murder against.
Okay, yeah, and
Charles
Law Nerd, was mentioning that she shouldn't be using it anymore anyway. I mean, I guess she's lost the right to once you unalive your or are involved in the unaliving of your children, you know, just use the married name. That's your your God role. That's how you became God under that name.
The government name, your government name.
Uh, yeah.
Okay, hold on, just a couple more
So
seconds.
Brian watched Benefield. Did they roll from the bench, Brian? Oh, he's coming back with a decision. All right.
Today, or he took it
I
under?
mean, he took it under advisement.
Hot pocket. Oh, okay. All right. So let's see. Okay, so I'm gonna.
Oh my
I'm gonna.
gosh, we missed an argument of Lori lawyering for herself. I don't want to miss that.
That's what I'm saying, sis.
Uh,
Like I'm saying, we got shit that we could like kill time with, but
well, we'll
let's
come
see.
back. We'll come back more prepared. Come back more prepared
I mean, look,
and ready to go.
even knowing nothing about it, we're going to be more prepared than Lori was. All right.
Yeah, but it's likely if we start with that this thing will start up, you know.
All right, I'm going to make it for 2 our time because that way I can always start it early.
Right.
But like, I think people do not get the notification if I start it late.
Yeah, and I think you can probably change the time to an earlier time before you start early, and then they'll get a notification, right?
Yeah, I think so. I think, yeah, I can always edit the time.
I mean, if you think about it, because you're assuming that they're going to start at around 1 o'clock, like they're going to do this, take lunch, and then start at 1 o'clock their time. Is that how you came up with 2?
Yeah, exactly.
All right, it'll be you and you only. I forgot.
What?
With your dad.
Oh, my dad's really trying to dip on that doctor's appointment. He was laying the groundwork last night. I think I should cancel that doctor's appointment. He kept saying it. You never acknowledged him, though.
I know, because he shouldn't. So,
I mean, what is that thing for?
all right. I mean, it's for an off-air discussion.
Oh, it sounds like it's superfluous, is my point.
All right. Let's just
details.
get your thing done. I got to tell you what's going on.
Take it easy. Take it easy, Mank. All right, hold on. I'm almost done. I'm working on the portal as we speak. Portaling. Working on the portaling. Okay. Okay. All right. Customization. Okay.
I mean, everyone will be gone by the time you get it up. So,
Hey, take it easy, man. Take it easy.
oh boy.
I have to see if this is the right one. Schedule. No, see, it's like it's showing. Ugh, I hate when it does this. All right, so wait, I created that. So hold on. Let me just double check here. Okay. Let me go here. Okay, I re-upped it. Sometimes it takes a second for it to pop up.
Okay.
Because what's showing up is I'm redirecting it to the live that exists now.
Uh-huh.
Get rid of that. Okay, let's see. I'm gonna refresh here. Reload site.
You know, for anyone interested, I just saw somebody post drone. So it made me think about this. News Nation did a little piece with a whistleblower, UFO, non-human intelligence whistleblower yesterday or the day before. It was pretty interesting. pretty interesting. He's got some photographs of a craft he recovered while he's recovering it from his helicopter.
Mm. Mm.
Melissa saw it.
Oh, wait. I figured
The
out what
egg.
I was
That's
doing wrong.
right. That's right.
I forget what I was doing wrong. I
Yeah, well, you
figured it
lost
out.
100 people while you were figuring it out, so you know.
Oh, well. We'll miss you guys. We'll miss you guys. We'll miss you so, so much. We love you so, so much. All right, hold on. All right, I'm almost done. I'm almost done. I'm figuring it out. I'm figuring it all out. Okay. Here, I figured it out.
So Crystal says that video was idiotic. I mean, I don't know. The guy seemed to be, if we're talking about the egg thing,
Eggman?
no, that this video on the
I
second
looked out
half
the
of
window. I
it,
seen his bald head. What?
on the second half of this News Nation video, I was like, huh, you know, but I mean, there's a photograph of what he recovered, and there's a lot of people.
Okay, I'm done. I did it.
Okay.
All right, so y'all are redirected. So when it starts, you guys don't have to do anything. You should automatically be waiting in the next thing. So you'll just hear my big mouth talking. Like you'll be sitting in your kitchen, like doing something or laying on your couch
Ali did
or
not forget the call.
sleeping, and then you'll hear me speaking, and then you'll know. Benfield is a tearjerker. Carrie. Oh my God. I'm gonna have to look at that. I'm gonna look at that during the break here. See, thanks, Law Nerd Amber. It says, oh, we don't have up our frame where it says Tech Wizardry.
That's all right. I didn't
Okay.
know when I opened it up, it still said Delphi Unhinged, so I just grabbed whatever I could.
Oh, Valo submitted a motion to
I
dismiss.
saw that. Let's say goodbye to people so we can.
All right, love you guys. We'll see you in a bit.
Bye.
Bye.